So as Mark said, the topic of our presentation is sexual relationships for adults with impaired capacity, and specifically looking at the law in different jurisdictions on that topic. So when the criminal justice system is assessed in relation to people with disability, it's commonly in the context of matters such as the overrepresentation of people with disability as victims or defendants, the accessibility of the justice system, or the suitability of correctional facilities. And it's often concluded that the justice system doesn't offer adequate protections to people with disability. But what is less frequently considered is how the criminal justice system, in its protective capacity, could adversely affect the rights of people with disability. And it's equally important to acknowledge that aspects of the criminal justice system do place restrictions on the rights of people with disability that don't apply to people without a disability, and therefore that creates a situation of inequity. So of particular interest to the Office of the Public Advocate are restrictions that criminal law places on the rights of people with disability to engage in relationships and to express their sexuality. So on that basis, we've recently commenced a project that's intended to identify and analyse the criminal law regarding sexual offences in each state and territory, with a particular focus on legislation that might apply specifically to people with a disability. So our research to this point has developed that there are two different but related themes that emerge from the legislation regarding sexual offences. And the first theme is consent. So the majority of sexual offences in every jurisdiction turn on the issue of consent to sexual activity. All jurisdictions consider issues such as the meaning of consent, when consent is freely and voluntarily given by a person, and situations where consent might be negated. And the second theme that we've located is the provision of special protections. Special protections arise where lawmakers take an interventionist role and they develop targeted legislative provisions that are designed to offer additional protections to specific groups, generally children or people with a disability. And nearly all of the Australian jurisdictions have special protections for people with disability, and they relate to the commission of sexual offences and more generally to sexual activity. So what's become apparent from our research is that the legislation in each jurisdiction can be placed onto a continuum. And the continuum ranges from a protective approach, which is based on the notion that people with disability require special legal protections, to a capacity-based approach. And a capacity-based approach doesn't assume that people with disability require a special protection, but it focuses upon the traditional notion of consent, and it looks toward the person's capacity to consent to sexual activities. So as part of our research, we've explored where each jurisdiction falls on that continuum. And our office also intends to explore how these approaches align with the rights of adults with impaired capacity, particularly as they're articulated in the Convention on the Rights of Persons with Disabilities, focusing on the balance that necessarily needs to exist in maintaining appropriate protection, but also recognising the rights of individuals. So in each Australian jurisdiction, there are provisions that are designed to protect people from sexual abuse. And although there are differences between the states and territories, in each jurisdiction it's an offence to engage in sexual intercourse with another person without their consent. And as Claire noted in her speech, those provisions apply equally to people who have a disability or any form of impairment. Consent is defined differently in each jurisdiction, but it generally includes requirements to the effect that it's given freely and voluntarily. In all the jurisdictions, except for Queensland and Western Australia, there's also provisions in legislation which specify that a person's consent can be negated if it's caused by their mental incapacity to understand the nature of the act to which they've consented, or to freely and voluntarily agree to the act. Queensland and Western Australia don't have those specific provisions, but the definition of consent in Queensland is defined as freely and voluntarily given by a person with the cognitive capacity to give that consent. So in that way, Queensland introduces a person's mental capacity into the concept of consent. There have been a number of court decisions regarding the meaning of consent, and generally courts have held that the existence of an impairment alone isn't sufficient to negate a person's consent. So what needs to be proven is an incapacity to understand that the act of penetration was of a sexual nature, as distinct of an act of a different character. But where a person does understand the sexual nature of an act, they can still be incapable of free agreement if their incapacity prevents them from understanding or exercising their right to refuse. The courts have also stated that an understanding does not need to be complete or sophisticated, and that sufficient rudimentary knowledge of what an act has comprised and its character of the act is sufficient for consent. Also, in Queensland specifically, the Court of Appeal has said that it is wrong to reason that because a person has an intellectual impairment, a lack of cognitive capacity must follow. So, the majority of jurisdictions have also enacted specific provisions that have the intention of protecting people with a disability or an impairment from sexual abuse. And what our office has done is reviewed these provisions, considering both the substance of the provisions and how they might uphold or restrict the rights of adults with a disability to engage in relationships and to express their sexuality. So again, as Claire identified in her presentation, Queensland has a specific provision that applies to people with disability. And that's section 216 of the Criminal Code, which states that any person who has or attempts to have unlawful carnal knowledge of a person with an impairment of the mind is guilty of a crime. And carnal knowledge essentially refers to sexual intercourse. In Queensland, it's also a crime to engage in other sexual behaviours with a person with an impairment of the mind, which broadly speaking includes indecently dealing with the person, procuring the person to commit an indecent act, exposing the person to an indecent act or an indecent matter, and taking indecent images of the person. In Queensland, it's also an offence for a person to sodomise or attempt to sodomise a person with an impairment of the mind, or to permit a person with an impairment to sodomise him or her. And finally, it's an offence to procure a person with an impairment of the mind to engage in carnal knowledge. So in Queensland, with the exception of the offence of procurement, it's a defence to show that the accused person believed on reasonable grounds that the person was not a person with an impairment of the mind. And it's also a defence to show that the act or omission constituting the offence was not sexual exploitation of the person with the impairment of the mind. So one thing to note about the Queensland legislation is that the defence regarding sexual exploitation essentially operates as a reversal of the onus of proof. In the majority of sexual offences, it's a requirement that prosecution prove that a victim did not consent and therefore had been sexually exploited. And if this can't be proven, then an accused person would generally be found not guilty. But the effect of this particular defence is that the onus is now on the defendant to prove that the person with an impairment was not sexually exploited. The legislation in Queensland has a wide potential application, and this is because the definition of the term person with an impairment of the mind is very broad. So it includes a person with a disability that is attributable to an intellectual, psychiatric, cognitive or neurological impairment, or any combination of those. The disability must result in a substantial reduction of the person's capacity for communication, social interaction or learning, and in the person needing support. So this definition has the potential to encompass a lot of people with a disability who, in spite of their disability, do have the capacity to choose to engage in a consensual sexual relationship. And the breadth of that definition was acknowledged by the Court of Appeal in a 2004 decision. That decision was about section 216 and the phrase intellectually impaired person. The phrase intellectually impaired person has the exact same definition as the phrase person with an impairment of the mind. It's just that the term has been changed. So in the 2004 decision, the court acknowledged that an intellectually impaired person often does have the cognitive capacity to consent to sexual intercourse, and that the mere existence of an intellectual impairment doesn't mean that a person is incapable of giving consent. The court did note that that impairment is relevant when determining whether a person has the cognitive capacity to give consent. So that decision seems to indicate, at least amongst the Queensland judiciary, that there is some recognition that people with an impairment of the mind can engage in consensual relationships. But section 216 is still in place, and the legislation isn't particularly restricted in its application, so it could apply to many sexual relationships. There don't appear to have been a great number of prosecutions under the provisions, and that could be a reflection of the recognition arrived at by the courts. But again, the fact remains that the legislation in Queensland is of such a breadth that it could have applicability to many sexual relationships involving a person with a disability or an impairment. There is some argument that the defence that a particular act did not constitute sexual exploitation gives some recognition to the fact that a person with an impairment can engage in a consensual sexual relationship. However, there's an equal argument that recognition in this manner is essentially insufficient. In making a lack of sexual exploitation operate as a defence rather than as an element of the offence, the Criminal Code has effectively created a situation where many relationships involving persons with disabilities could be contrary to law, but some of those could then be proven to be legal later on by way of the existence of a defence. So there's therefore the potential for a consensual relationship involving a person with impairment to be the subject of a criminal charge and a court proceeding, with a requirement that a defendant prove a lack of sexual exploitation. Then this would necessarily involve the person with disability in the criminal justice system as a victim and as a witness, which, as we all know, brings with it many other issues of access to justice. And whilst the defence may ultimately be proven, this would come at a cost to all the parties involved. In New South Wales, there are also specific provisions in this space. Section 66, capital F, subsection 2 of the Crimes Act states that it's an offence for a person who is responsible for the care of a person with a cognitive impairment to have sexual intercourse with that person. And essentially a person is responsible for care if they provide any type of voluntary care, healthcare, education, home care or supervision at a facility for people with a cognitive impairment or at the person's home in connection with a facility-run program. And that's a responsibility that can exist generally in relation to the person and also at the time of the offence. New South Wales also has another provision, subsection 3, which provides that a person is guilty of an offence if they have sexual intercourse with a person who has a cognitive impairment with the intention of taking advantage of that person's impairment. So the consent of a person with a cognitive impairment does not operate as a defence in New South Wales, but it is a defence for the person to show that they did not know the person had a cognitive impairment, that they were married or in a de facto relationship with the person, or that the act constituting the offence was carried out for a medical or hygienic purpose. So the legislation in New South Wales can also be viewed as quite broad. Similarly to Queensland, the legislation describes a person as having a cognitive impairment if they have an intellectual disability, developmental disorder, neurological disorder, dementia, mental illness or a brain injury that results in that person requiring supervision and social habilitation in connection with their daily life activities. So again, this definition has the potential to encompass many people with a disability who might in fact have the capacity to choose to engage in a consensual sexual relationship. However, where the offence falls under the more general provision in subsection 3, the application is in fact somewhat restricted. And that's because it's a requirement of that subsection that the accused intended to take advantage of the person's cognitive impairment. So if that intention does not exist, then the offence cannot be proven. In some ways that sounds similar to the Queensland position, where it's a defence to show that the act was not sexual exploitation. But the main difference is that the onus of proof has not been reversed, so the responsibility of proof will still rest on the prosecution. As a result, the legislation in New South Wales does appear to allow people with disability to engage in consensual relationships and to give recognition to their rights. But it also recognises that people with a cognitive impairment might require additional protection and provides those firstly through the specific provisions relating to people who are responsible for care. New South Wales also has an additional unique provision regarding consent, and it states that where another sexual offence has occurred, for example an indecent assault or an act of indecency, the victim's consent to that sexual activity is not a defence if the accused was a person who is responsible for care or a person who intended to take advantage of the person's cognitive impairment. So this expands the protections available to people with disability, but still doesn't affect their more general right to engage in consensual sexual intercourse. So in the Northern Territory, they've enacted specific provisions which are targeted at service providers. And section 130 of their criminal code states that it's an offence for a person who provides medical or therapeutic disability support services to a mentally ill or handicapped person to have sexual intercourse with or to commit acts of gross indecency upon that person. It will be a defence to prove that the accused person was the husband, wife or de facto partner of the mentally ill or handicapped person, or that the accused person was unaware of the mental illness or handicap. But it is not a defence to prove that the person consented to the sexual activity. So the effect of the provisions essentially is that in the Northern Territory, people with an impairment can engage in consensual relationships with people who don't provide them with support services. Where the person does provide them with support services and potentially therefore places the person with disability in a vulnerable position, the legislation does offer additional protections. But that legislation only applies if the person is mentally ill or handicapped. And this is restricted to people who, because of an abnormality of mind, are unable to manage themselves or to exercise responsible behaviour. So it doesn't extend to people with a disability in general. In Tasmania, there are targeted offences that are similar to those in the Northern Territory. And the Criminal Code provides that it's an offence for a person who is responsible for the care of a person with mental impairment to have sexual intercourse with that person. It's a defence to prove that the person with mental impairment consented to the act and that the giving of the consent wasn't unduly influenced by the fact that the person was responsible for their care. It's also a defence to prove that the person was married or in a significant relationship. So the Tasmanian legislation also doesn't criminalise people with a mental impairment engaging in consensual sexual relationships, as long as they're not with a person who provides them with support services, or with a support person if their consent is not unduly influenced. Where a person does provide support services, and again potentially places the person with disability in a vulnerable position, the legislation offers that additional protection. And the additional protection applies broadly because in this instance the term mental impairment is only defined as referring to senility, intellectual disability, mental illness or brain damage. There's no qualification regarding the effect of the impairment on the person's abilities. So although there is a defence in cases of true consent or in cases where a relationship exists, the section does have a broad potential application. Like Tasmania and the Northern Territory, Victorian legislation also has targeted offences. In Victoria, the legislation applies to people who provide medical or therapeutic services to people with cognitive impairment, and also to workers who deliver developmental or educational programs for people with cognitive impairment who are residing at or attending a facility, where the person with cognitive impairment is not their spouse or their domestic partner. So sections 51 and 52 of the Crimes Act provide that service providers and workers must not take part in an act of sexual penetration with the person with cognitive impairment and must not commit or be party to the commission of an indecent act with a person with cognitive impairment. There are a number of defences available in Victoria, and all of these defences only need to be proven on the balance of probabilities. So where a person provides medical or therapeutic services that are related to the person's cognitive impairment, it's a defence to prove that at the time of the offence, the accused reasonably believed that the person did not have a cognitive impairment. And if the services were not related to the person's cognitive impairment, then it's a defence to prove that at the time the accused was unaware of the cognitive impairment. Generally, consent is not a defence to the charges, but it does operate as a defence if the service provider or worker can prove that they reasonably believe they were the person's spouse or the person's domestic partner. So the Victorian legislation has many of the same effects as the Tasmanian law. It doesn't criminalise people with a mental impairment engaging in consensual sexual relationships with people other than service providers or workers. But those specific provisions related to service providers and workers do apply quite broadly. The term cognitive impairment, again, is only defined as referring to an impairment because of mental illness, intellectual disability, dementia or brain injury, and it makes no reference to the effect of that condition on the person's capacity. The law is dissimilar in that it doesn't recognise consent as a defence, but it does recognise genuine relationships. So in South Australia, legislation applies specifically to persons with a disability, and Section 49, subsection 6 of the Criminal Law Consolidation Act makes it an offence for a person to have sexual intercourse with another person, knowing that the other person has an intellectual disability and cannot understand the nature or consequences of sexual intercourse. Consent is not a defence, although it doesn't apply if the two persons are married. So the application of the legislation in South Australia is not restricted to certain offenders or relationships, but it is restricted in that it only applies where a person's disability means that they cannot understand the nature or the consequences of sexual intercourse. It does not have a general application to all persons with intellectual disability, meaning that many people who do have that understanding can engage in consensual sexual relationships. And in that way, South Australia has given recognition to the concept of capacity. South Australia has also recently introduced a disability justice plan, and that includes a proposal to introduce new legislation that's based upon the existing New South Wales provisions. So, like New South Wales, it would be an offence for a person who's responsible for care of a person with cognitive impairment to have sexual intercourse or indecent contact with the person. Consent would not be a defence, but it would be a defence to show that the accused person didn't know about the cognitive impairment, that the parties were legally married or domestic partners, or that the act was for a medical or hygienic purpose. Now, the South Australian Office of the Public Advocate argues that the current legislation in South Australia is often just seen as a lesser alternative to a charge of rape, and if anything, it protects an accused person without providing special protection for a person with disability. They state that the current legislation tends to assume that people with an intellectual disability are incapable of understanding acts, and also that it could encourage people taking actions that are designed to prevent people with disability from expressing their sexuality. So the South Australian Public Advocate has argued that current legislation is not a sufficient deterrent, and that these proposed amendments may offer a greater level of deterrence to people who seek employment with vulnerable people with the intention of committing offences. Legislation in Western Australia has some similarities to the existing South Australian legislation. The Criminal Code provides that it is an offence for a person to sexually penetrate or indecently deal with another person who the offender knows or ought to know is an incapable person. And it's also an offence for a person to procure, incite or encourage another person who the offender knows or ought to know is an incapable person to engage in sexual behaviour or to do an indecent act. It's a defence to prove that the accused person was lawfully married. So the effect of these provisions is that in Western Australia, people with a disability are able to engage in consensual sexual relationships as long as they don't fall within the meaning of the term incapable person. And the term incapable person is defined as a person who is so mentally impaired by an intellectual disability, a mental illness, brain damage or senility that they are incapable of understanding the nature of the sexual act or of engaging themselves against sexual exploitation. So looking at that definition, the term incapable person doesn't extend to people with disability in general, and it's arguably a restricted definition because it requires a fairly incomplete incapability in respect of sexual matters. So the effect is that many people with disability can engage in consensual sexual relationships, and the protection is not unduly prohibitive. So like South Australia, Western Australia has given recognition to the concept of capacity. In the Australian Capital Territory, the sexual abuse of people with disability isn't subject to any specific provisions, and it's governed only by the usual legislation prohibiting the commission of sexual offences. Their legislation does note that consent would be negated in certain circumstances, including if it is caused by a person's physical helplessness or their mental incapacity to understand the nature of the act that they're giving consent to. And consent is also negated if a person abuses a position of authority or trust, which is relevant in instances such as where an offender is a carer for a person with a disability. So, to summarise all of that, the review of legislation in each jurisdiction has demonstrated that when approaching sexual relationships for people with disability, there's essentially a divide between jurisdictions that take a protective approach and jurisdictions that take a capacity-based approach. So in Australia, the most protective approach is taken by Queensland. The broad nature of the legislation and the reversal of the onus of proof mean that the legislation has the potential to apply to many people with disability, some of whom might actually have the capacity to consent to a sexual relationship. A hybrid approach is taken by New South Wales, Victoria, Tasmania, and the Northern Territory. These jurisdictions all have legislation that's designed to protect people where there's a care or a support-based relationship. But with the exception of New South Wales, they don't have protective provisions of general application. New South Wales does have a provision of general application, but it applies only where there's an intention to take advantage of a person's impairment. A capacity-based approach is taken by South Australia, Western Australia, and the ACT. In South Australia and Western Australia, the legislation only applies where a person's disability is such that they cannot understand the proposed sexual activity, or they cannot protect themselves from exploitation. So the focus of the legislation there is on the nature or the quality of the person's capacity to consent, and the legislation should not apply to a person who possesses that capacity. So it's arguable that a capacity-based approach is most reflective of the rights of those with disability to engage in relationships and to express their sexuality, and of the rights that exist under the United Nations Convention on the Rights of Persons with Disabilities. So the Convention firstly provides that people must be protected from all forms of exploitation, violence and abuse. Now, this might naturally give rise to an argument that protective laws are necessary, given that people with a disability are potentially vulnerable. But there's also an argument that a more balanced approach in this space is to offer protection by the same laws designed to protect society as a whole, perhaps with additional provisions regarding consent or caring relationships. This could arguably offer people sufficient protection without unduly encroaching on their rights. And the Convention also provides that people with disabilities must be treated on an equal basis with others with regard to marriage, family, parenthood, and relationships. So people with disability have the right to marry and found a family, access age-appropriate information and education about reproduction and family planning, and be provided with the means necessary to enable them to exercise these rights. Arguably, a capacity-based approach takes steps toward implementing this right. And finally, the Convention requires that people with disability be provided with the same range, quality and standard of free or affordable healthcare and programs as are provided to other people, including in the area of sexual and reproductive health. In order to provide people with disability with equivalent healthcare and programs, legislation must permit the provision of those things. Where legislation is not permissive of sexual relationships, policies and programs to support a person's sexuality cannot be properly implemented. Therefore, in order to uphold persons' rights and make provision for such programs, capacity-based legislation is arguably required. But if a capacity-based approach is to be preferred or utilised, then the question that arises is how do you assess the capacity of a person with disability to consent to and engage in sexual activity or sexual relationships? So in Victoria, government policy has recognised that people with a disability have the right to engage in legal and non-exploitative relationships of their choice, to receive support, education and resources to understand their rights and responsibilities, and also to create opportunities for developing social networks. And responding to that, the Victorian Office of the Public Advocate has developed guidelines for advocacy and guardianship in relation to sexual expression. And those guidelines state that capacity is decision specific and it might be limited to a particular relationship or a particular type of sexual activity. They describe capacity as the ability to understand, retain, believe, evaluate and weigh information relevant to the subject matter. And they state that when assessing capacity, the key ability is the evaluation of the information, which involves demonstrating an ability to apply that information to a particular situation. So if a capacity-based approach is to be taken, then this must go hand in hand with an obligation to build the capacity of people with disability to understand and consent to sexual activities. In jurisdictions that take a more protective approach, particularly, for example, Queensland, legislation may limit what can be done to build a person's capacity and support them to have sexual relationships. In some other jurisdictions, legislative limitations may pose less of an issue. It is arguable that even in more protective jurisdictions, people with a disability can be educated regarding sexuality, and in fact should be educated, if only so that they can recognise and report unwanted sexual behaviour. This is a topic that our office intends to continue to explore over time, including possibly a determination of what represents legislative best practice and a consideration of whether there is a need for legislative change. That consideration must also include a consideration of what other systems might be impacted upon or require change, for example, the issue of access to sex workers. It's not an issue that can be easily resolved, but it is an issue that we must work towards resolving. Thank you.
Thank you, Elise. Question? Patrick.
I was just going to say that was an excellent survey of all the relevant provisions, and you should consider publishing that in the Criminal Law Journal or some journal like that, so a wider audience than just this group could consider it, because is very, very well done.
Thank you.
And your reflective commentary on it would, I think, also be really useful for practitioners.
Any other comment, questions?
There's a great irony that we have a continuum from protection to capacity around consent, and yet the number of people who are raped, the number of people who actually get reported, the rape get reported, and diminishes to investigation.
My interesting reflection is that it's all right to be married. How do you get there? Some marriage was a defence in all of that. But, how to construct a relationship in order to get there could be a concern.
So marriage is a bit of a narrow definition of relationships.
That's right. But it's an interesting reflection.
And also, when you say protected, if you actually have a speech, you put it down. If you were having sex, that the person who was having sex with you would be found guilty of
Potentially.
Just the whole sort of issue that we touched on earlier, and was something that we wanted to sort of talk about, was about sort of same-sex relationships and how that fits into this stuff as well, which doesn't seem to be.
We can't even get
Yeah.
second one over the line, negative.
Yeah. You know what I mean? Like, there's just nothing there, is there, that sort of indicates that that's even a possibility, which we know as practitioners that actually real ones. It's not like that, guys.
I think I don't know, it's fortunate and unfortunate in many respects. There are differing definitions for spouse and partner and things like that across different legislative instruments, but they don't limit them to only heterosexual relationships in the way that those at least are defined. So that at least is in that favour. But
And I think there's also the definition of what constitutes sexual intercourse in each jurisdiction is different. So some of them do encompass same-sex relationships, some of them it's more questionable whether they do or don't.
Yeah, I'm not a legal person, but I find this the references to health intervention, like the design, defence, medical or hygiene.
Yeah, well, that reference, I mean, I know that when I was working with people with detention, so it was it was a requirement for all females go in and out of that detention centre to have an internal examination. Now, the girls who experienced that were held down by 4 male wardens, while a medical officer did an internal examination. Their experience was not great because they actually, so it does, it's interesting. Any other comments or questions?
Yeah, I just wanted to make a comment and just, I suppose, really just express thanks to the Office of the Public Advocate for raising this issue and for your wonderful presentation. I think it's something that actually has significant impact in the day-to-day work in terms of supporting people with impaired decision-making capacity to be able to have healthy, safe, happy, pleasurable relationships. So, thank you.
Thank you.
Thank you.
Thank you.